state, and you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have relevance in the first chap. Therefore, you should have dealt with it. On balance, as of today, the law would be interpreted in my favor. But here, I'm on something else. To come back to the point here,
No, I thought it fit to ask you that for the reason that no notices were issued on these two complaints is what you said. That's the reason.
The reason is this.
Yes.
That he felt that he had issued one. The reason is hurry and lack of application.
That's fine. Yes.
That's the real answer.
Let
us be practical. The real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice on that complaint to him. I got two more. I said, I've already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well,
but I must now come back to this. This is very, very interesting.
I wanted clarification.
No, I'll be dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll cite those two judgments because the court has gone very far there on natural justice, telling your lordships how important it is. Therefore, there are three. One more thing I want to say, natural justice, before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute.
We will have to read into the statute.
In Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there is no question about it in this case. But let me come back to this intervention by Mr. Raghavan just now.
Yes.
Well, as your lordship will see the number of occasions and how strange this is. You have now, just now told your lordship that I did apply for sanction. Right, Wallace? And this document which Mr. Singhvi is reading is of course not the sanction because I'm reading a document that doesn't seek sanction. Now, Wallace, this document I read just now, I didn't read my own friend in Kannada, Wallace.
Yes.
Is actually attached to the objections, right, Wallace?
It is.
Now let us see what the objection says. It says this is the application for sanction. This is the problem. When you make up the story as you go along, the problem is this, Wallace. Truth has a very strange way, Wallace, of getting caught up in all kinds of webs. Now let's come to para 55. That was the intervention 2 minutes ago. Now you should see what your deponent has said.
Para 55.
Yes, page 43.
What of what?
What is
Objections.
Private complaint filed here. Which is here, the next year before trial court. In fact, talk of 31/7.
We are now considering a proposition. Just note what are these 4 dates. The original complaint by application by Mr. Ibrahim, that is R3. Then the application by Mr. R5. Then the order of sanction, show cause. Then the sanction order. Then my petition to your lordships and detailed hearing on that. Then 2 days ago counters, and then today's hearing. In between, there is also police complaint filed, PCR. None of them mention 31 July. I forgot to mention on 8th of August, PCR is also filed. I'll give you a list.
There is no mention about this.
Of this. But the mention in the affidavit, which will prevail on pain of perjury, is this, para 55. We have to go by this, not by what is said orally. Since the accused one is the present Chief Minister of Karnataka, the competent authority to accord sanction for prosecution is His Excellency. This is the averment to which this is annexed. The competent authority to accord sanction for prosecution is the Excellency. Accordingly, the complainant has also sought for the sanction and permission from the governor under 19, under 55, under 197, under 218, under 200, which is pending consideration. It is pertinent to note that since the allegations against the named accused persons are not in relation to any action taken or recommendation made by accused one or other named accused, there is no requirement of prior permission of approval from the competent authority under 17A. This court can consider the complaint on merits without any legal impediment. The copy of the same is appended is 35. This 35 is 376.
Yes.
Whereas I counted 6 dates from the first date. Again, whereas I'm not meaning facetiously, there is a saying,
What
6.
is This says 28, all the list of documents are there. There's no 27 here.
Give me the date of the application, 2 applications. Whereas in between these dates, write down the dates in a piece of paper. Write it here. In between, on 8th of August, I forgot to mention, a PCR is filed before the trial court. And Malas, that PCR on 8th of August,
That is where you read from. Para 55 is the part of that complaint.
that's right.
Yes.
It's an X there.
Yeah. No, no. Now you read 55
Yes,
at page 43 of the objections. That is
That's
a part
right.
of the complaint itself.
that's right.
PCR.
And it is not, Malas, noted anywhere about 31 July. Stop this.
No, all the documents say there is 31/7.
And Malas, the document index, what is this volume?
It's the same R4.
Malas, this R4's reply has a list of documents which runs up to Malas serial number 35. You have to see the list of documents. Obviously, I can't show negative. There is no 31 July whisper of a mention.
That's not there.
Therefore, Malas, this by itself, Malas, again, I'm sorry that these are Malas, analogies which are arising from the natural course of conduct done by the respondents, not me. But there's a saying, the first time it is happenstance. Second time it is coincidence. Third time it is enemy action. This is the 6th time, not third time. Therefore, Malas, 17A today on R3 and R4 and R5 has not filed any reply. And I don't have any documents about him. Today, Malas, is clearly. Then, Malas, the 4th sub-aspect of 17A is a very, very strange and quite amazing aspect. The argument is that this offense allegedly took place in Malas, whatever, 2005, 2007, 2010, whatever date you take. Various dates can be. In 2010 or 2005, etc., you cannot apply 17A retrospectively.
That's his submission.
Whereas with great respect, this argument has to be only stated to be rejected. Because if you choose to file a complaint after 10 years, 15 years, or whatever years, and then you have it both ways, I will file a complaint today but not comply with the law of the land today, which is of some, hoary antiquity already now. Then, it's an argument which has to be stated to be rejected. These are, my 4 or 5 sets of arguments on 17A, on which I submit alone, not that this is the only ground, but alone, this entire thing falls to the ground and should be set aside, etc. Now, the next point I wish to come to, is to remind your lordships about the statement made by the governor just now, a little earlier, saying that, look, I don't wish to file any reply. Your lordship remembers that we had said that the governor has specific names and dates with investigation, after investigation of complaints pending. And if your lordship will turn to well, I don't have to give your lordship the note, just note the details, annexures from 693 to 696 and 701 to 702. These are much prior complaints in some of which investigation is complete, charge sheet is filed. The names are Malos Sashikala Joli, Murgesh Nirani, H.D. Kumaraswamy,
Charge sheet is
Nardan
filed.
Reddy.
Charge sheet is filed.
Investigation is complete in any
Complete.
case.
Charge sheet is not yet filed.
In one Malos, I'm told. In one.
Because without sanction, charge sheet cannot be filed.
Take out details. What is it? Yeah, but it's investigation complete, therefore a charge sheet is filed subject to the sanction. That is the correct
Charge sheet
way.
is also filed.
Yes, yes. Yes, yes.
All right.
Today, Malas, when I say that anybody comes to you and you immediately grant, well, the person who granted has at least these 4 names I have given. And the pages are Malas 693 to 695, then 696 and 701. This is an article 14 points straight away, staring you in the face. Now, Malas, there is no reply and none. And in fact, last time orally it was said, orally, that we will let you know about this. Specifically said.
No,
Now-
he has now also said that he will produce the records completely.
So, Malas, that is, no, but the fact of the, correct, no problem. Records are between the court and there, no problem. But the fact of the matter is that these 4 are actual real human beings, actual real complaints and applications, actual real pendency, much earlier dates, investigations complete. That's all that I'm saying. I don't think the record, whatever is produced, can be different. Now, Milits, the next aspect is another simplest, straightforward point without meaning to over-amplify or oversimplify. The sanction must go. I'll tell you why. Your Lordship has now held absolutely crystal clear that sanction is fully reviewable. That is beyond doubt. The law has got well ahead of that. It's completely and totally judicially reviewable. The 2 judgments amongst many Amalus, Mansukha 1997 and Yedurappa 2015. My compilation has them. I'll just take your Lordships to them. So it is completely reviewable like judicial review of Malus administrative public law action. Be it Malus for ulterior motives, lack of application of mind, Wednesbury unreasonable, etc., etc. My Lord knows that well. There is, apart from that, Malus, I have given detailed additional law also, and I will Malus cite some of that. Well-established principle. Rameshwar Prasad, State of Gujarat, R.A. Mehta, and of course, very homely flavor of Karnataka, S.R. Bommai. Directly, Malus, they say, it's fully reviewable. I've got the paras also. 9 judges down to division benches. Now, Malus, the beauty of this case is that the governor has not applied his mind or dealt with a single point on the merits of the sanction. I repeat, that's why it's a simpler case. Not applied his mind or dealt with. Whereas you can even deal with the subject, which shows that you've dealt with it without applying mind. It is possible. But for not applying mind, for me to show non-application of mind, I must show that you've dealt with it. The governor has not dealt with a single point. One point he deals with. I am not bound by the cabinet advice. So let me for a minute accept the Honorable Governor and proceed from there. I'm not accepting this, but I'm just saying, please proceed for a minute. You are not bound by the cabinet advice. Let us take it as it is. Therefore, you are acting on a tabula rasa. The tabula rasa is that this man has applied, this application has come.
No, this requires an independent decision. Sanction against this, the chief minister or other
Therefore,
functionaries.
I'm for a minute
It is an
accepting.
independent decision of the governor. He cannot fall back upon or need not fall back upon the advice of the ministers.
I am Malas proceeding on that basis.
Yes.
There are some nuances in Nabam Rebia.
Ah.
It is. But I'm not arguing that. I want to make it simple first. For a minute, please assume against me and in favor of the governor, as my Lord felicitously put it, independently decides. He is the cabinet, not bound by the cabinet.
Yes.
He is the complainant. He or she comes to me. I am the governor.
In this particular issue,
Yes.
not in every issue. He is definitely bound by the
No,
bound
no,
or
we are
to follow
talking of
aid and-
sanction. We are talking of
aid and
sanction.
advice definitely is there.
No.
But
on
in-
the sanction,
on the
regarding a
sanction,
chief minister.
yes.
So Malas, we need not trouble ourselves for a minute. For this purpose, at the moment, I am assuming against myself. So Malas, what happens? I am the governor. He or she complains. as a lordship use the word independently, I have to give. Now turn to page 41. There's nothing.
No, that will,
There's nothing.
that you have told. Yes.
What do I show your lordships? There is nothing. There is only one point. I received a complaint. I received an advice. I am not bound. Hence, I grant sanction. I don't want to exaggerate, but I repeat. Is that not sufficient to quash the sanction? My lord used a milder word just now, independent.
No,
It has to be an
independent decision making.
objective consideration with reasons, with application of mind reflected in the order. There must be something. It can't be that because I'm not bound by you, therefore I must grant sanction. That's what the order says. Therefore, Maharaj, this on the merits is the most strong ground on the merits of the sanction I'm now. And it is sufficient to set it aside. Now let's
Yes.
just pick up that bunch, only the index. I'm not going to read it. To
The
let's give the index. Of the
judgments?
Yes, just to tick it, just so Lordship knows where is what. Is it all here? Where is sanction is reviewable? Sanction is reviewable. Where? Which one? The index where? Well, it's
Here.
there are some of them which are separate, so I have to little scattered. May I make my lords just stick it? In this large bunch, one is scattered at serial number 2 at
Acha,
I'm sorry, you should not have put new serial numbers every time. Why do you make an index like this? No, it's not the index. We have put Malos fresh numbers each time, so it creates some confusion. If your lordship sees Malos page 2,
Page 2, sir.
of the index.
Yes.
So one is Malos Mansukh Vithaldas Chauhan.
Next is.
Yes.
And the paras of this Malos are. The paras don't make me wait. You are
Para
complete
14,
mess.
17, 18 and 19.
Para 14 to 18. In fact, 14 to 19.
Yes, sir.
Take out. These are the
Of
paras.
Mansukh Lal Vital Das.
That your lordship has ticked below the number 2. I'm sorry, our index should have had continuous numbers, but we don't have.
No, that's
it's
all
number
right.
2.
No problem.
Yes.
Yes.
Then Malas,
20.
Yedurappa
22 to
is on the next page, number 5.
22 to 30. Para 22.
Yes.
Here, Malas, para 22 to 30. But I have also culled out the more specific paras like 27, 28, 30. Malas.
Yes.
I will also, Malas, give a lordship a digest of just the paras with the extracts to make it shorter. Later on.
That's better.
That. Will you make a note of that? Just not all, just the relevant ones, the underlining highlight. Just otherwise it's much easier. Now, Malas, in addition to that, point 11 below. The other judgments, Malas, which talk of judicial reviewability very clearly is the Constitution Bench of Ramesh. Where is the bunch?
Yes.
This is Malas, a volume 2. These are high-powered numbers in terms of benches. Malas. The numbers are larger. Constitution bench is 9 judges.
Yes, sir.
So one is Malas Rameshwar Prasad, which is the number 4 serial on the first page.
Yes.
Here your lordship may write on the margin, or I'm sorry, maybe I have to give it to lordship writing, but it's 128 and 129. This is a constitution bench, 5 judges.
Yes.
And Malas 140 to 145,
Yes.
para numbers. The previous 2005 Rameshwar Prasad, para 7 will suffice.
Yes.
So 2 Rameshwar Prasads,
Yes, sir.
both are constitution benches. Well, the state of Gujarat, where is state of Gujarat? Well, I'm very sorry. What we'll have to do is extra, because we've given them all over the place. So I'll give the
It's all
extra.
right. No problem. Yes.
There is well, a state of Gujarat, which is 2013, 3 SCC, page 1, para 68. I had the privilege of assisting the court here.
So all of these are concerning Article 356.
So, Malas,
What is that you want to rely on?
so I'm saying, Malas, governor's actions.
Ah.
The narrow ones I've given you first two are Mansukha and Yedurappa.
Yes.
But Malas, I am saying governor's actions are fully reviewable even in the A for sure I category,
No,
totally and completely.
I have no doubt about
That's right.
it.
That's
Yes.
so I'm just Malas, this is 45. That's why I'm not reading it.
Yes.
I'm not even reading it, Malas.
Yes.
I'm giving a lordship decided, and it's capped. It's capped by Bommai in Malas the paras. So what I'll do is, with your lordship's permission, I will take Malas extracts and only some of them and underline them and give it to your lordships. I am not even reading them.
Yes.
It is too well established. Now, let's on the natural justice part.
Same compilation.
Please note the 3 dates first. Yes. Whereas, note 3 dates. A show cause is given to me on 26/7/24, which is at page 265.
Yes.
And Malas, what? Date of my reply. Date of my reply.
3.
And Malas, meanwhile, in the interstices of the government, the AG has given an opinion on 31st of July 24, as the documents now show, at page 267. And the cabinet note is at 1 August 24, which also attaches the AG's opinion at page 336. But what is missed out here is that I separately replied on 3rd of August 2024
Page 6.
at page 630. And I was also cited a lot of law and all the details, etc., etc. Now, all of this is decided by the order at page 41, dated 16th of August 2024, which, as your Lordship has already noted,
Yes.
adds this gratuitous sentence that R4 and R5, which is para 2 of that document, page 41, para 2, which is when I first learned of it. But this is one part of natural justice. Natural, very many parts of it. This is A. Part B of natural justice is that all the points I have raised, forget the cabinet, you're bound or not bound, I'm not bothered. I have raised these points of diverse nature. You have not dealt with any. Any. That's point number 2 of natural justice. It is, your Lordship has the order 41 to 46. I can't add to it. I can't subtract to it. Nothing. Files also, which are uncommunicated, can't, as far as the final order is concerned, add reasons. You can't say that I wrote an order like this, that I had 28 reasons in my file back home. That is not an order. You can't justify, Now, in this light, your Lordship put a question on the scope and nature of natural justice. So before I read those 2 judgments, take them out, keep the paras ready. I want to just give your Lordship first principles, 3 or 4 points, then your Lordship will. One is adverse civil consequences, bina pani day. Second is the consequences here are much beyond adverse civil consequences, because it is not only the person who is the chief executive of the state. I have said in the opening that the larger constitutional issue is that if you are elected with a full-throated election where huge amounts of money are spent by the opposite side, but still you lose, somebody is elected. He may be bad governance, he may be a horrible governor. Only the people who elected have a right to remove him. If you can use this methodology to remove him or initiate removal, then it's a negation, which is why all safeguards have to be read. Obviously, if somebody is steeped in crime and you have material, yes, give reasons and start removing him. But every filtered safeguard must stand at the threshold, because you are negating the mandate of the people. If you accept this larger principle, and your Lordship state, Karnataka,